This conference will now be recorded.
Definitely. That clock's about 5 hours off, so. I call to order the August 23rd, 2023 Area Board of Zoning Appeals of Tippecanoe County meeting. First item is the roll call.
Steve Clevenger.
Present.
Gary Schroeder.
Here.
Tom Andrew. Robert Novak.
Present.
Michelle Dennis.
Present.
Ed Butts.
Present.
Dustin Grove.
Present.
Quorum present.
Thank you. I'll take the approval of the previous meeting minutes, please.
I move to approve the minutes from the July 26, 2023 ABZA public hearing as submitted.
Second.
Motion and a second. All in favor?
Aye.
Opposed? Motion carries. New business.
All cases are ready.
Thank you. Can I go ahead and have the public hearing motion, please?
I move that there be incorporated in the public hearing portion of each application to be heard this evening and to become part of the evidence at such hearing, the Unified Zoning Ordinance, the Unified Subdivision Ordinance, the Comprehensive Plan, the bylaws of the Area Board of Zoning Appeals, the application and all documents filed therewith, the staff report and recommendations on the application to be heard this evening, and responses from checkpoint agencies.
Second.
I have a motion and a second. All in favor?
Aye.
Opposed? Motion carries. I'd like to briefly describe our procedures for this meeting. Each case will be heard following a motion and a second from the board. We'll ask the staff to report on its findings. Following the staff report, we'll ask the petitioner to present his or her case, after which anyone wishing to support the petitioner's request for variance or special exception will be asked to come forward. After hearing from the petitioner and those speaking on his or her behalf, we will ask those speaking against the petition to present their arguments. The petitioner will then be allowed to rebut arguments raised by those in opposition to his or her petition. Following the rebuttal, the board may wish to ask questions of the petitioner, supporters, and opponents of the petition or of the staff. The staff will have the opportunity at this time to make any necessary clarifying comments. We will then vote by use of a prescribed ballot. 4 votes are necessary to make any decision. In the absence of 4 votes, either for or against, the petition is automatically continued to the next meeting. Please observe the following guidelines for the sake of time and fairness to all. State your name and address for the record before you speak. For those that are not the petitioner, or the representative, we do have a sign-in sheet for you to sign in after you speak. Please limit your remarks to 5 minutes or less. Do not repeat arguments that have been brought up by others. Remember that all visual aids used to support your arguments will remain the property of the board. Cell phones must be turned off while the meeting is in session. Please step out of the room before using your cell phone. And with that in mind, we'll hear the first case.
Mr. President, I need to recuse myself from the first case.
Thank you.
I move to hear and vote on BZA 2104 Archview Properties, LLC. Petitioner is requesting a variance to reduce the required parking standard from the minimum required 2 spaces per dwelling unit to 1.75 spaces per dwelling unit for a proposed apartment complex in an R3 zone. The 26.581 acre site is located between County Road 50 West and County Road 100 West, or Yeager Road, south of Hawthorne Ridge and just north of the West Lafayette city limits. Wabash 31, Southwest 24-4. UZO 4-6-3, continued from the June 28th ABZA hearing at petitioner's request. Second continuance.
I second.
We have a motion and a second, and I also would like the record to reflect that Gary Schroeder has recused himself from this case. And we'll hear from staff, please. Amanda?
Thank you. Amanda Esposito, APC staff. The property in this request is just north of the West Lafayette city limits and just southeast of a request that this board heard just last month for the Buckingham Group. This property was recently rezoned to R3 in preparation for filing a multifamily subdivision complex. Being in the county, the parking is based on the number of units, and they are requesting a variance from that parking requirement. Currently, the property is just in row crops. Nothing has been improved out here. Closer up. And here is the site plan. You'll notice that it does encompass the entire 26-acre site, but they are requesting, this variance is, they do have, I believe, 2 lots here as part of the subdivision. So we're looking at just the left-hand side. So in the county, as I said, the parking count is for 2 spaces for every unit. The multifamily apartment complex is calling for a maximum of 290 units, requiring 580 spaces. They are showing 509 parking spaces on their site plan, which is roughly 1.75 spaces per unit. We've been told that the development will consist primarily of 1-bedroom units, which decreases the amount of parking that would normally be required from multiple bedrooms and units. As well as, city bus. So city bus runs along Yeager Road here currently, so public transportation is readily available. The newly realigned Yeager Road will also have a walking biking trail that leads into West Lafayette. And because of these alternative modes of transportation, as well as the dominance of the 1-bedroom unit, staff is in favor of this request and is recommending approval. Happy to answer any questions that you might have.
Thank you. And we'll hear from petitioner, please.
Thank you. Good evening. Kevin Riley, attorney with Riley, Teeter and Schreier, representing the petitioner. As was mentioned, we are requesting a variance to reduce parking standard from 2 spaces per dwelling to 1.7 spaces per dwelling. We do appreciate Amanda's summary. We agree with everything that she said. We did want to mention, though, or reiterate that this will be largely a 1-bedroom and studio development, so 66% of the units will be 1-bedroom or studio, with 34% being 2-bedroom units. So therefore, we don't think that 2 spaces per unit is necessary. We think that if you have 2 spaces per unit, this is going to be an overparked development. We agree, for the reasons that Amanda stated and the reasons I just gave, that we meet all the requirements of the ordinance for the granting of this variance. And I think it was also mentioned in the staff report that they view the parking standards as outdated for the county. So we think that is another reason why this is an appropriate request under the circumstances. Happy to answer any questions that you have.
Thank you. Anyone wishing to speak in favor of the petition? Anyone in opposition to the petition? Questions, comments from the board?
Steve, I do have a question for the petitioner.
Sure.
In the supporting facts, number 1, you stated that the reduced number of spaces would decrease traffic and vehicles. How does that work?
Well, our theory would be that if you have fewer vehicles on site because of less parking, you're going to have less traffic.
But if you're saying the parking you're requesting is enough for the facility, it shouldn't matter how many parking spaces there are because you have enough. It's not going to increase or decrease traffic based on the number of parking spaces.
That's true, although you could have people that park in spaces that you could have more guests, you could have more people bringing in cars if there are more spaces. So you could have people from outside of the development park there. Maybe that's unlikely, but it's possible.
Do you have, the way it's laid out right now, would you have, if this doesn't pass, do you have enough land surface to approve or to fit in 2 spots per unit?
I am going to defer to Evan Bryant with the developers here, so I'll see if it's, Evan, do you have a response to that, please? Sure.
Yes, we would have enough land.
Can we have your address, please?
Oh, sorry, yes. Evan Bryant, 10 West Carmel Drive, Carmel, Indiana.
Thank you.
Yeah, we could expand. Reality is, we didn't think we needed the parking. Usually 1.5 to 1.75 is kind of our target. We have the land under contract. We needed to build outside of it, but we thought we'd have a sea of parking and add a cost, and it wasn't going to add anything to the property, so that's why we're asking for the variance.
But between drainage, green space, setbacks, and everything else, you could fit the additional spots in there?
Yes, we've already tried it. We could. Just prefer not to.
Okay. All right, thank you very much.
Yep.
Any other questions? Hearing none, we have a ballot.
There are 5 votes cast, and 4 are in favor, and 1 is against.
The variance is granted. And we'll wait for Gary to get back in here. And we'll hear the next case, please.
I move to hear and vote on BZA 2111 Tomish Developers LLC. Petitioners requesting a variance for a proposed multifamily apartment complex to allow required parking in the 60-foot front setback from Veterans Memorial Parkway West in an R3 zone. The required 5-foot no parking setback would be met. The 10.4 acre property is located on the southwest corner, check that, southeast corner of US 231 South and Veterans Memorial Parkway West, across from the Southern Winds Apartments, and WEO 7 Northwest 22-4, UZO 4-4-6. That was continued from the June 28th ABZA hearing at petitioner's request. That was our first continuance.
Second?
Have a motion and a second, and we'll hear from staff, please. Ryan?
Okay, here's our site. It was, subject property was rezoned earlier this year from NB to its current multifamily zone. As you can see, the site's unimproved. There's an existing curb cut directly across from the Southern Winds Apartments that enters the site. And that would be the principal point of entry for this proposal. Let's see, in terms of land use patterns, obviously it's an area that's under development, not too much going on around it, kind of on the southeast corner of the city. Sewer was extended to serve Southern Winds, so this is sort of the kind of the current limit of public utilities in this particular location. Again, the site's unimproved. Here's the proposal. Relative to transportation, obviously, again, they're using that existing curb cut as their main entrance. A transit service is currently not available in this location. The amount of parking is consistent with the zoning ordinance requirements, so that's not at issue. Of course, public utilities are available to this site, just stretching it across the street. In terms of the content of our report, staff could find really no issues with the site, it's spacious enough to be able to reorganize the parking in order to meet the requirements. And so we were not convinced that this variance is required. And so in terms of the tests, they really fail on number 4. This is a situation that is common to a site such as this, given its size and disposition, and that the hardship is self-imposed because of the particular site plan they're interested in delivering. So again, staff wasn't convinced on this request, so we are recommending denial. Be happy to answer any questions.
Thank you. Petitioner, his or her representative.
Good evening. Excuse me, Kevin Riley with Riley, Teeter, and Schreier, representing the petitioner. Yes, we are seeking a variance allowing parking in the front setback. This property has sat undeveloped for years, and it's been underutilized for years. As it's set up, the right-of-way, the property line is about 50 feet from the edge of the right-of-way for Veterans Memorial. So even if we park within that front setback, we're still 70 feet away from the right-of-way edge, which is still a significant setback. There won't be any, we're not asking to locate buildings within the setback, just parking within the setback. I would note that we submitted a sketch plan for the subdivision to area plan a month or so ago. It showed the parking within the front setback, and as far as I know, we weren't told that, at that point, we were told to go ahead and go forward and file the sketch plan. So at least at that point, we didn't see it as an issue. We don't believe that granting the variance will be injurious to the public health, safety, or welfare. This doesn't, what we're asking doesn't encroach on any property. For the same reason, we don't think that the use and value of adjacent properties will be impacted. I did want to note that we do think this is a unique situation. We've got a piece of ground here, again, undeveloped for years, underutilized, and it's already substantially set back from the right-of-way. So we don't think that added front setback is really appropriate in this case, and it is a unique situation. For those same reasons, we think that the strict application of the ordinance will create an unusual and unnecessary hardship, and that hardship is not self-imposed by the petitioner. I would note that we believe we're seeking the minimum relief needed. Our initial request was, we reduced our initial request by 15 feet, so we asked for 15 feet more on the variance previously. We then went back and reworked the site plan, and were able to reduce it to where we are now. So we have made strides to meet that standard. I'm happy to answer any questions that you have.
May I have some in a second for you? Sure. Later.
Okay.
Anyone wishing to speak in favor of the petition? Anyone in opposition to the petition? Questions, comments from the board? And I do have one. You say that the property is set back 70 feet, or that you're set back 70 feet from the right-of-way?
It's 50 feet from the right-of-way to the property line, and then if we had this additional setback.
Who owns the property between the right-of-way and, are you talking the curb, or are you talking about the right-of-way?
The edge of the right-of-way, so that would be either state or county. I don't know who owns Veterans. It's not privately owned, what I'm talking about.
Because usually your property begins at the edge of the right-of-way, unless you're talking about the edge of the curb.
No, because if you look at least if you look at the GIS, it's got a gap there, which is, I believe, either the state or county right-of-way. So as I understand it, our property line does not go up to the edge of the road.
It does not? So it's probably like a drainage extended?
Yeah, this is
possibly-
outside of city limits, so the
Okay.
county owns and maintains the right-of-way along Veterans Parkway.
So the right-of-way is probably actually an extended right-of-way,
Because
probably
of veterans.
for drainage.
And because of the nature of the road, the way that it's
Right.
classified, it's a 60-foot setback from.
Well, there's
Yeah.
a setback you've got the right-of-way.
And then there's
with
a
the
setback.
property line.
Yeah.
And then you got the setback from
Right.
the right-of-way.
So essentially two setbacks.
So there's,
Correct, yeah.
okay. So it sounds like it's an extended right-of-way for whatever reason.
Primary arterials.
Yeah.
And that's why we think this is unique. I mean, we've got the setback, the right-of-way area that's unimproved, and then we've got the additional setback that we're agreeing to.
Go ahead, Gary.
So I guess to follow up on what Steve said and looking kind of at this drawing and the topography, is there maybe a drainage right-of-way, or is there a drainage easement? Is there a ditch between the road and the property line, and that's why it's extended?
I mean, my understanding is, and from what Ryan said, it's just because it's a primary right-of-way, you've got that additional square footage between the property line and.
It
and the
sounds
right-of-way
like,
edge.
I believe the right-of-way, you said 70 feet, is what the thoroughfare plan has for a primary arterial. So
For
it's
all
actually-
properties
so it's
along Veterans
for all
Memorial.
properties. So they're actually.
Right.
You have 70 feet of right-of-way from the center line of the road, and that's the property line.
Correct.
And then you've got, then have the 60-foot setback from the
that
property
property
line. So
line.
there is no intervening extra property. It is just a standard right-of-way for the primary arterial.
So is a 60-foot setback from your property line, so you'd actually be parking on your property, not in the right-of-way? And you're
Correct.
still- And you're still 5 feet away from that setback from a property line?
Actually, we are.
They're at least 5 feet away for the parking. The road, I'm not sure. The access road to the parking, I'm not sure if that's.
So what I was getting at is you're on your property.
Right.
Yeah.
It's just that.
We're in the front setback of our property.
Yeah,
Yes.
right. And there's kind of an extended setback from the road for some reason.
Correct.
Normal. Okay. I think I understand it. Thank you.
And looking at that map, it looks like there's a dotted line that is set back probably 60 feet. That's right outside not that one, the one that's inside the building. That's probably the 60-foot one right there. Like
Yes,
the
that is
60-foot
correct.
60
That's
foot
the
for
60-foot
buildings, and then the
setback.
parking is in.
And parking is not allowed in that area.
In that as well, correct.
Yeah.
So you'd have a huge area out front that you couldn't park in. That whole parking area could not be there. Any other questions?
Well, so is this extended right-of-way that affects this property, is it that way, is that how Veterans is then? So it's not necessarily unique to this property? Everyone's
Correct.
having to do
All
this
properties
additional-
along Veterans Memorial
Have this
have the
double
same-
setback? Yeah, okay.
Any other questions? Hearing none, we have a ballot.
There are 6 ballots cast, 5 in favor, 1 against.
That variance has been approved, and we'll hear the next case, please.
Mr. President, I have a question about our agenda, if I might.
Sure.
as I was recused and roaming the hallways, I ran into someone who was at the meeting, and I see most of our agendas have citizens' comments and grievances at the end, and I don't see that on our agenda, and I think she is here to have a public comment. I wouldn't want her to wait any longer. Do we have that? Do we take public comment at the end of this meeting?
Oh,
It's
would
not-
like to,
It is not provided for in the bylaws. The chair, with the consent of the body, can have public comment if they so desire.
So I would ask you to make a decision now, so either she can go home or wait until the meeting's over to express, or if you would, what's your
I
decision?
mean, I do not have an issue with hearing, comments from the
Public
public.
comments.
If the board agrees to that.
And it'd be your call unless you were
So-
overruled,
Right.
which you,
So does anyone have any objections?
I would say as long as it's not about some upcoming case.
Right,
That
yeah,
we're
we
gonna
we
hear,
can't, we can't hear about a specific case that is going to become before the board.
Right, okay. Very good, thank you.
Thank you.
Next, I move to hear and vote on BZA 2115, Michael Kieswetter. Petitioner is requesting a variance to allow a 0-foot setback instead of the required 25-foot from the right-of-way of Eastbrook Drive for a recently installed utility shed. The property, zoned agricultural, is a corner lot located at 4850 Eastbrook Drive. It's in Washington Township, 36 Southeast 24-4, UZO 2-24.
I second.
Have a motion and a second, and we'll hear from staff, please. Amanda?
Thank you. This property is located kind of north and east of Lafayette, out in the county. It is in an older subdivision developed in 1970, back when major subdivisions could be done in the rural zoning districts. So it is zoned A. The rest of the subdivision, as you can see, is zoned R1. That happened a little bit later. This property is on the corner of Eastbrook Drive and Eastbrook Drive. And it is on private well and septic. You can see in the aerial here that there's a single-family home on the left-hand side of this facing the western property line is a two-car garage that is attached. A small concrete slab goes to the north, just away from that garage, and that is where the new one-car detached garage is located, and which is the subject of this variance request. The rest of the property has, as you can see from the site plan, a large septic field in the northeast corner, and then going back to the aerial, several large trees which kind of limit the space that is available to the petitioner for additional buildings on the property. The roads in this subdivision are rural local, and they require a 25-foot building setback along the road. The roads do not have any kind of curb or sidewalk, so it does make the property appear larger than it actually is, I believe, not having that limiting line along the road where a sidewalk, where you would normally know that my property starts outside of the sidewalk. So that may explain why the garage was placed on the property line. We did get this request by way of the building commission. A call was made for an inspection out here, and they determined that the shed was placed without a permit and that it might have been placed a little bit too close to the road, which led to this variance request here. It was determined that the shed was placed right on the property line, so they are asking for a 0-foot setback. While the nature of the property might make a 25-foot setback a practical difficulty and a practical hardship, from the UZO standpoint, this is not a UZO-defined hardship, so we were not able to recommend approval in this case, and we are recommending denial. I'm happy to answer any questions.
Thank you. Petitioner, his or her representative.
I'm Michael Gieswetter at 4850 Eastbrook Drive. So, yeah, we're requesting this. Part of it, we want to use this building as privacy. When you come into our neighborhood, you have to come in on Eastbrook or Eastbrook, and so we are basically the one house that's, almost everybody sees as they come in. So occasionally we get some kid foot traffic through our property, so it'd be nice to have some way of blocking that off, and having a structure there or fence is helpful to eliminate that. Another thing is there's a lot of other properties in the neighborhood that do have additional structures. There's a property that has a 30 by 40 pole barn just down the street, and then just to the next corner, a property that has several additional detached garages. One's 3,000 square foot, another one 480 square foot. So our request for an additional garage space isn't out of the ordinary for a neighborhood. Additionally, I want to use that as a garage, and that pad helps to go into that garage. And actually, our house is, the attached garage is actually past our setback. And so if we move that shed over a lot more, we won't be able to access the garage door on our shed. So we need to have that as close to the property line as possible to still be able to access, to get a vehicle inside the shed. And then I also have a petition signed by most of the neighbors. I got 12 signatures on here saying that they're accepting of where the shed is at right now. So. I guess that's it. Any questions?
We may have some for you in a minute.
Okay.
Thank you. Anyone else wishing to speak in favor of the petition? Anyone wishing to speak in opposition to the petition? Please come forward.
My name is Mike Graham, live at 120 Michelle Court. Our concern is if this is allowed to stay, what's going to stop everybody else from putting them right along the curb? I understand it's a corner lot, which you really don't have a backyard. You got two fronts, and it's right out there where everybody sees it. That's my only concern.
Okay, thank you. And if you could please sign in at the table. Anyone else in opposition to the petition? And if the petitioner would like to rebut?
I think we're in a unique case where we do have the two frontages, and so when we have 100-foot wide property, 25 feet back is cutting a quarter of our property off. There's not that many more properties that have it that are going to be able to request that additional space. I mean, he's a neighbor that has another one of those corner properties, but he's got the additional of a lot that he gets to have his extra detached garages on. So he's got all that extra space.
Okay, thank you. Questions, comments from the board?
I have one clarification on page 2 of the report. I think there may be a typo that I wanted to make sure the record reflects. paragraph numbered 4, there's nothing usual with this lot, and I think that's probably was intended to be unusual. True? So if the record could reflect the
That is
correction
correct.
at page 2, paragraph 4, second sentence, to change the fourth word to unusual, please.
Good catch. Any questions from the board? Michelle?
Amanda, can you go back to the aerial of the neighborhood? I can't see it too well on the... Oh. Thank you. Sure. Are you allowed to put fences up in the neighborhood? Or is that against an HOA or anything like that? Would that have been an option for privacy?
I did install a partial fence. There's no HOA that prohibits it. But I mean, that also adds the cost, or I wouldn't be able to put a garage in there if I put a fence blocking that.
Any other questions? Robert?
Petitioner?
May I speak, please?
So our public comments are over.
I want to speak to this.
Our public comments for this are over. It's
Hold on,
questions
you
from,
voted.
it's questions from the board right now.
Sorry, I missed the question.
Yes. So just to clarify, the garage is already built, correct?
Correct.
Does it have electricity to it?
No.
And you didn't pull a permit?
I guess I didn't realize I needed one for a portable building. So.
It's a portable building,
Yeah, Yoder's portable building.
so it could be moved or slid over?
Yes.
Thank you.
And I guess if anyone would like to recognize the lady, I mean, I will. It's up to the board.
I would recognize her for a few minutes to hear what she has to say.
Please come forward and give your name and address, please.
Okay, my name is Cheryl Kirkpatrick. My address is 801 Carrollton Boulevard in West Lafayette, Indiana, 47906. If I understand this, the question is about whether or not they can have something closer to the street than the 25 feet. Am I correct?
It's actually closer to, it's 25 feet closer to the street. They built on the property line, so it's not at the street, it's at they built on the property line when there's a setback of 25 feet. So it should be 25 feet further from the road.
Well, but we're in the case, does it say that it's not 25, it's 0? Where's the 0?
The 0 is because it's built on the property line. So it automatically.
The 0 is between the,
It's between, if you look at the picture.
I'm looking at this
On the monitor.
garage here.
The garage right there is built on the property line. What is between the property line and the road is actually owned by, I'm assuming it's county. So that's actually owned by the county. That's part of the road right-of-way.
Okay.
So the property line begins right there where the garage is. And they were supposed to actually set that back 25 feet from the property line, so it'd be 25 feet further from the road than where it is.
Okay. So therefore, we want a special exception because this is going to be for our advantage.
A special exception is not
No, I'm just using those
Okay.
words,
Okay.
because basically that's what it is. And if I can do it, and you give me permission to do that, then my neighbor, every direction can do that also, because I will already have been given that permission. Is that correct?
No.
It won't open the door for everybody
No.
else?
Okay. I mean, I think we've answered what we can, and you probably need to talk
I
to
hope
a
so.
lawyer about it.
I hope that you consider the fact that if you weren't entitled to do something and it's not going to help anybody else but yourself, why should you be allowed to do it?
Gary, you had a question?
Well, if she comes back, oh, there it is, I guess. Most of the time when I consider a setback, is it going to have a side hindrance for the road? And I didn't see the big picture. Does that road just go down and curve? You might back that, so that's not a T, that just goes and curves around.
It is a T intersection, and it is not in the the vision triangle that we
Okay.
consider whenever two roads meet. So it is
So-
outside of that vision triangle.
No, okay, that was my concern, it's not a safety issue.
Correct.
Thank you, Amanda.
Any other questions? If not, we've got a ballot.
There are 6 ballots cast, 3 in favor, 3 against.
That's an inconclusive vote, so we will hear the case again at our next meeting. And we'll hear our next case, please.
I move to hear and vote on BZA 2116, Angela D. Diaz. Petitioner and owner is requesting a variance for the front setback of an R1B zone from the minimum required 25 feet to 21.2 feet for a covered front porch. The property is located at 4615 Brighton Court, Wheel 18 Southeast, 22-4, UZO 2.3-7. I guess that's 2-3-7.
I second.
Have a motion to second, and we'll hear from Ryan, please.
All right. As you can see, this neighborhood is zoned R1B. There's R1 zoning, kind of dominates the rest of the area. There's some general business to the south, but kind of not really near this particular property. They're at the end of the cul-de-sac, so cul-de-sac lots always come in different shapes and sizes, and this is this one. Very angular, and not much room for kind of where to put the house. So the house does have an existing two-car garage. It was built to code, so it does meet the R1B standards. The existing covered porch is approximately 5 feet deep and 8 to 10 feet wide. Proposed porch will be 9 feet deep and 25 feet wide. Let's see if we can, there's a site plan there. The UZO does allow an uncovered porch to extend, but if it's covered, it's essentially part of the building. That's how building code would recognize it. So even though it's not enclosed and air-conditioned, because it has the roof, building code would say it is an extension of the building, as long as it's attached to the house. If it's detached, you're dealing with a detached accessory structure, which this is not. This would not be. So again, the house has been in use since the 1990s, I believe, with no incident, no issues. So as we apply the tests, the situation, I'll just run through a couple of the points. This is something that is not entirely common. Cul-de-sac lots, they do come in lots of shapes and sizes. So, but compared to other standard street lots, it is slightly unusual given the placement of the house and the setback requirements, why it was located in that specific location. You can kind of see the building footprint, buildable area that they're allowed to build in. I guess they wanted to favor a bigger backyard. Who knows? It was a while back. But regardless, the footprint's there, the house footprint's there, so they'll have to deal with that existing condition. But while it is unusual, it's not unique, and that was really for us the main test for number 5. The use of the home is not diminished by the non-expansion of the current porch. So in our minds, the tests just can't support this request. There is no kind of loss of use of the property as a result of a denial of this variance. So, so that's where we land on this. Be happy to answer any questions. Otherwise, we are recommending denial. We do have some schematics, and we'll leave it on the photo there. Be happy to answer any questions.
Thank you. Petitioner or petitioner's representative.
Hello, thank you for hearing us today. This is my wife Angel, and I'm Eddie Diaz. Address 4615 Brighton Court, that's where the property is located. We agree with everything that he pointed out. The house has been livable like that for 25 years. It was built in 1994. What the problem that we are running into is that we used to have a nice tree, maple tree in the front of the house, and 2 of our neighbors had big trees in front of their house. Earlier this year, the branches were coming down, so unfortunately we had to take ours down. And when we had the tree company there, they accessed the trees around our neighbors, and they end up taking their trees down too. So the whole cul-de-sac right now has no trees planted. So when we moved in 2020, when we purchased the property, we did have nice shadow in front of the house. Now the house is faced west, so the sun hits it constantly in the afternoon. The handle of the door is barely touchable in the afternoon of the front door. So it's very uncomfortable. We had our blinds just shut so we can protect maintain the temperature inside of the house. So what we're requesting is not go any further than what the existing sidewalk is to build right above where the sidewalk is currently placed. So we're not looking to expand the square footage of the property. It's just a little bit of protection for the front of the house and make it more livable or comfortable, I will say, because it is livable.
Thank you.
Thank you.
Anyone else wishing to speak in favor of the petition? Anyone in opposition? Hearing none, any comments or questions from the board? We have a ballot.
you. This paper is so damp.
It
from the
is.
humidity.
I've noticed that too.
Let's send that back down to Ed, if we could, please. Thank you. 6 ballots cast, 6 in favor, 0 against.
That variance is passed, and we'll hear our next case, please.
I move to hear and vote on BZA 2117 Moon 26E LLC. Petitioner and owner is requesting a special exception to legitimize an existing motor freight transportation and warehousing operation in an A zone, SIC 42, operating Monday through Friday, 8 a.m. to 5 p.m. The 18.048 acre property is located on the south side of State Road 26 East, 1/4 mile east of County Road 900 East, specifically 9271 State Road 26 East in Perry Township, 26 Northwest, 23-3 with conditions.
I second.
I have a motion and a second, and we'll hear from Amanda, please.
Thank you. This property is out on the east side of the county. 900 is just to the west, and then this property is just on the south here. It was rezoned just about 2 months ago to A in preparation for this special exception. The use that is currently operating on the site is only allowed by special exception in A zones, hence the rezone activity earlier this year. All other property around here is zoned AW. You can see that north of 26, it is all A. Mostly out here, it's row crop production, single-family homes, and you've got some floodplain from the Wildcat Creek down in there in the south. As I said, the property is currently being used by a motor freight transportation and warehousing business. From what I understand, it's been here for about 5 years. The petitioner, who is the owner of the property and does not run the business, but from what I understand, the partnership with the business, they just wanted to formalize it and came through this process to get all of that formalized. So the majority of this property is being used for row crops. The special exception site plan does limit it to just what is shown here at the top right-hand corner, kind of where all the trucks are parked. The entrance is off of, here's the site plan. It is, okay, so this is flipped. You can see there's a north-down arrow here, so we're looking at it from the opposite direction. I apologize about that. Here is the entrance off of 26. Because it is a state-owned highway, NDOT will need to review it just to make sure that it is in compliance with their entrance requirements. Pretty clear line of sight in either direction. It is a gravel drive. Parking areas in rural zones are not required to be paved, so this is very normal for rural areas. You can see leading into the back of the property here, the cab of one of the first trucks that are parked in the parking area. The petition lists about 10 to 12 dump trucks that they use for carrying aggregate materials to sites. This is part of the northern property line with the single-family dwelling to the north. That is not part of this request. Just wanted to point that out. They do have a couple of mature evergreen trees along this property line. 2 Quonset huts. The one on the left is owned by the petitioner. owner of the property, is not part of the special exception request. The one on the right, the smaller one, is used by the business. There's a dispatch office in the building there. The pole barn here was built just recently, and from what I understand, will be used for maintenance, occasional maintenance on the fleet of trucks. You can also see the driving lane on the right-hand side of the pole barn and another row of mature evergreen trees to kind of shield this property from that single-family home to the north. Here's where the employees park their vehicles. Kind of another view there. I would like to point out that while this use does not require any kind of buffering, the petitioner voluntarily installed an approximately 6-foot tall berm, a landscape berm with newly planted evergreen trees along the top of it to kind of shield the uses on this property here from to shield the property outside of here from this use, I should say. So they do meet the requirement for parking for this use. They are currently using a portable toilet, but they have already begun conversations for putting in a commercial septic, which is outlined on the site plan. Don't want to go too fast to make you all sick here. They have a proposed septic area kind of on the upper left-hand side of the site plan. Let's see. So concerns that staff have with this type of use in a rural area would be, the volume of heavier traffic that is driving on gravel roads, hours of operation, and potential negative aesthetic impacts. They have chosen to include the entire property in this special exception request, but they are limited by what is shown on the site plan. If they chose to expand at any point beyond what is shown on the site plan, beyond what they have included in the petition, they would have to come back before this board for an expansion of their special exception request. They have limited themselves by the amount of parking shown on the site plan, as well as the number of employees. They also limited themselves in the hours of operation to 8 a.m. to 5 p.m. Monday through Friday. So because of these self-limiting factors, and because it has been operating for about 5 years with no complaints as far as we're aware of, we are recommending approval with a condition, and because they are already operating, we are recommending that this board make a timeline for the condition to be met to obtain those necessary approvals from county departments and NDOT. So I'm happy to answer any other questions you might have.
Thank you. Petitioner, his or her representative.
Good evening, Kevin Riley with Riley, Teeter and Schreier representing the petitioner. Appreciate Amanda's summary. Really covers most of what I need to talk about. We believe that this request meets all of the requirements of the ordinance for granting a special exception for the reasons that Amanda stated and that are in the staff report. I believe, I agree, the neighbor to the north has consented to this request. Do you have a letter in the file or anything?
We don't have any letter from anybody, but your petition does state that the neighbor supports it.
So we have discussed it with the neighbor, and the neighbor's in support of that. The neighbor to the north, I should say. This is a low-intensity use, and as Amanda mentioned, we have already agreed to a lot of limitations on the hours of operation, days of operation, the vehicles, and the number of employees. So, and this has been in existence for 5 years with no complaints. So we think that it's appropriately tailored and narrowed, and we would request your approval.
Thank you. Anyone wishing to speak in favor of the petition? Anyone in opposition? Questions, comments from the board? And I guess I do have a question as to what you would think would be a reasonable time period to get the appropriate approvals.
You're working on those now, is that correct?
We have the approval for the septic.
Yes, we have.
And then as far as the NDOT, that's a whole nother beast there, but we can get on it right away.
We're thinking, would a year be, I mean, I think a year to give us plenty of time, but that would be my suggestion.
Staff have an opinion or?
Way to put me on the spot. No, I don't have any suggestions. The only reference that I have for a previous timeline on conditions was for 6 months, but I'm not sure if that's feasible or not with having to deal with NDOT.
Yeah, I know
I mean,
we're dealing
if
with.
NDOT requires, is it, I guess a question again for staff, is if it requires the necessary approval for NDOT, does that mean that they just need to be notified of what needs to be done? Or does that require them to, if they need to put in some type of concrete entryway, that be completed?
All of the above. We just want to make sure that
Okay.
it does meet commercial standards for an entrance off of a state road.
I guess I would add, we are working with NDOT on a different project, not the same type of issue, but still working with NDOT, and we're 6 months in, and we're still waiting for a response.
Anybody else on the board have any opinions?
I have a question for Mr. Burns. In this situation, they limited their hours of operation and the days that they operate. From what I could tell, they're basically running dump trucks. 8 a.m. to 5 p.m., does that mean a truck can't roll off the lot or back on? What does hours of operation, and no Saturdays?
Yeah, I think that's a fairly clear and bright line. We've got a 8 o'clock, you can start business, which means trucks can roll in or out. 5 o'clock, you're done with trucks rolling in and out of the operation of that business. I suppose if the owner drove in and out all weekend, that's not operation of the business.
Petitioner, I guess I turn to you then. Do you think that realistically that means a truck can't roll on or off on a Saturday or a Sunday, and it can't leave the yard before 8 a.m., and it has to be back there by 5?
And that's what we've committed to in order to make sure that this doesn't create any issues for neighboring properties. That's how I would interpret it as 8 to 5, Monday through Friday, no Saturdays, no Sundays, in terms of the operation of the business.
And staff, that was a condition?
That was not a condition, that was a self-imposed limitation that they put on their petition. So we're fully in support of that.
So if it was a self-imposed, if we approve it, then they're limited to that?
Correct.
Okay.
With regards to the timeline, is it something to where if we go with a year, and I have no clue if that's reasonable or not, I have no prior knowledge to base it off of, but is the assumption then if we get to the year mark and things haven't been resolved with NDOT, I'm assuming that some sort of extension would be able to be granted as long as there isn't negligence on behalf of the petitioner. Is that reasonable to expect?
I was going to defer to our attorney.
Could we add language to that?
This board would have the authority to extend it,
Okay.
and that would be determined at that time. If they came forward, then you would consider that probably under administrative matters or other matters someplace on the agenda.
Okay, so it wouldn't just be that variance is revoked and sorry about your luck type
No,
of
but if
thing?
it went for 18 months and they didn't ask for an extension, that'd be a problem.
Yeah, the onus would be on them to be staying on top of it, but assuming everything was in fair play, then that's, okay, thanks.
I mean, if it's, 10 or 11 months and it looks like they're not going to have everything completed and signed off by then, I would expect them to file something and come back before this board.
And we understand the need to move on this. We don't intend to
Yeah,
sit- we
yeah,
don't
but like I
intend to
said,
sit
there's a
on
lot
it.
of it that's out of your control, so I wouldn't want you to be punished for bureaucracy, so,
Yeah.
okay.
I mean, I guess we need to add that to the condition.
So I would move that we add a condition that the conditions that are already attached be completed within 1 year from the approval of this, if it gets approved.
I second that motion.
Any comments on that? All in favor?
Aye.
So you have 1 year to get the necessary approvals
Okay.
listed under condition 1.
Thank you.
Any other comments or questions? Hearing none, we've got a ballot.
I have 6 ballots, 6 in favor, 0 against.
Special exception is approved. Administrative matters. And we had somebody that would like to speak for citizens' comments.
Did you have something to say that I talked to you in the hall?
Yes,
Yes.
Yeah,
Yes, I do.
Okay.
Thank you.
and you have 5 minutes.
I could probably take that all. Okay. I live in West Lafayette on Carrollton Boulevard, which is part of Hills and Dales. And just recently, I found out that an Airbnb has come into my neighborhood, which is around the corner. And not only is it one Airbnb, but there are 2 on the street, which are about half a block long, the street. Okay. The owner I ran into by mistake, she informed me, we have rights too. And I thought, well, yeah, you do, but that doesn't make it okay. Yes, you got the Zoning Board of Appeals to go ahead and vote for you to do this Airbnb in my neighborhood. But you would not ever have an Airbnb in your neighborhood because it would wreck your $1 million home value. You live on one of 2, Northridge and Ridgewood. Both of those streets, if you live in West Lafayette, you know those streets are the most prestigious and old valued homes and streets in West Lafayette. If you want to live someplace good, that's where you went to live. Because when I was growing up, those homes were all owned by doctors. And so there are no Airbnbs that are going to go in there. No, no, no. So you come to my neighborhood, which is, as the crow flies, about 2 blocks away, and tell me you want to make money and you have the right to do it. And yes, you do. Does it make it good? No. Does your right to make money make you happy, honey, that you are turning the neighborhood into a wreck with your 2 B&Bs? Because have you taken into account, in Hills and Dales, it's called Hills and Dales because we don't have any streets that are gridiron. They're all looped around. And that means that these 2 Airbnbs have backyards that don't just touch that house and that house, but go around the corner on Woodland to the house 2 doors in there and 3 doors in there because their backyards come there too. Because you don't have alleys like you did down on University, Waldron and Russell. So does anybody take into account that when they said these are the boundaries for a lot, that would happen, that all these people's backyards would end up having to deal with all of these different individuals. So the noise, obviously, is a problem. And now we know that there are 6 people allowed to go and live in this house because they have 3 bedrooms. But the 6 people have to have 3 people related. Okay, now what are the chances that 6 men who are coming in for the football game or the basketball game are going to be 3 of them related? Probably they are. They're fraternity brothers. Doesn't that make them related? And how will we know or not know unless Mrs. Downing goes and checks on their IDs and finds out if they have the same last name? I doubt she's going to do that. I doubt she's going to do anything to improve the situation. And people say, well, then guess what? You'll have to call the police about the noise, because the first Airbnb that is there has disturbed the people across the street since it was put in there. Now the question is, why is it my responsibility to call the police to come and get these people to be quiet? It isn't my responsibility. You can't come in here and make it my responsibility to check on your house. It's your responsibility. Give me your phone number so I can call you at 3 o'clock in the morning. Or knock on your door at 3 o'clock in the morning and tell you your Airbnb is out of control. And come take care of it. Do you see the problems? You're imposing upon the neighborhood people because of your desire to make money. Why can't you take your money and go invest it someplace else? Why do you have to bring a commercial property to an old residential neighborhood that has been around for 80 years? My house was built in 1951. There wasn't even a street in front of my house. Therefore, they gave me an address. Okay, I got it. So that's how long my house has been there, and I don't want any more Airbnbs, unless, of course, you want to put them in your neighborhood.
Thank you.
I see we have larger boxes on the ballot, so I appreciate that. It was easier for me this evening.
And I guess a comment on the Airbnbs, I would talk to staff and your city council, about it. I mean, we have limited things that we can do.
To that, I appreciate your comments and was also disappointed in the decision, but we are working with the city council and with the city attorney and with staff to try and see what options we have to better protect areas like that, because I agree with you. So it is, we're working with also some of your neighbors as well, have also reached out, of course. So it's something that we're aware of and trying to see what options we have to offer some more protections. So,
And if there are violations, please contact, area plan staff as well, because they're in charge of violations.
Down on Bexley Road and Iowa Street.
Yeah, we really can't debate it, so it's,
Trash all over the yard every weekend.
thank you. Unless any member has an objection, the chair will order the findings of each member casting a vote for the majority decision of the board to be the collective findings of the board in support of the decision of the board. Hearing none, it is so ordered, and I'll take the last motion, please.
Move to adjourn.
We are adjourned.